All right. Hello and welcome back to Cambridge LLP's WillPower Wednesday. Thank you for joining us. And it's great to be back from our holiday break and back to our live episodes. My name is Benjamin Bernier. I'm an articling student in Cambridge LLP's Estates, Trusts, and Wealth Planning Group, and I'll be the host for today's proceedings. I'm pleased to be joined by our esteemed panelist, Tristan Audet. Tristan is a senior lawyer in the Estates Group at Cambridge LLP. Her primary expertise is in estates matters, involves the complex drafting of wills and trusts, and particularly those involving minor children, disabled beneficiaries, and aging relatives. Tristan also advises executors and estate trustees in the execution of their role and has guided many through the process of passing accounts. All of that, which I think makes her the perfect panelist for today. So before we get started on the topic, as always, I just want to point out that there will be a period for audience questions at the end of the proceedings. However, should a question arise during our discussion, please feel free to enter it into the chat function, and I'll be sure to raise it to Tristan. So our topic for today is Making the Grade, a primer on passing of accounts. By the end of this webinar, we aim to provide you with a better understanding of the process for passing accounts, and we hope that by the end of the day today, you'll be better informed of, one, what a passing of accounts truly entails, two, why a passing of accounts becomes necessary, three, who can help you through that process, and four, what are the best practices to ensure that the process goes well. So our discussion for today centers around a topic which often arises during our estate administration files at Cambridge LLP, and today we'll deal with a few maybe hypotheticals that come about too. So with that context, I think now would be a great time to bring in our panelist, Tristan. Let's start with some broad strokes, because I know that for some of our audience, seeing the notice for this week's episode might have left a few more questions and answers. I have to admit that before my time in an estates class in law school, I had never heard of this term before. So for that reason, let's start with a really simple explanation of a passing of accounts. What is the one sentence explanation of the process?
So a passing of accounts is actually a court proceeding. It's where you go to a judge and you say, Judge, here's the transactions that I've made for this period of time. Please approve them because the beneficiaries either haven't or can't.
Right. Okay. So follow up to that. Who might have to pass accounts and why?
So anybody who's acting in a fiduciary position may be required to provide a formal accounting. So that's people who are acting as estate trustees, that's people who are acting as powers of attorney, or if they're acting as a trustee of a formal trust.
What's the kind of layman's term explanation for fiduciary?
So essentially what you are doing is you are acting in a position of trust, which is a fantastic word to use when I'm talking about trust law, but you're acting in a special relationship to the money that you are managing for another person.
Right. So there's certain responsibilities that kind of go with it.
Correct. Yes. By taking on the position as a power of attorney, as an estate trustee, you're accepting the responsibilities that come with that.
Right. Okay. So now that we kind of have the simplest terms of what a passing of accounts is, why kind of more practically does one come about?
So in a perfect world, you act as the estate trustee for your parents, you deal with the estate, you report to your siblings, everybody says, yep, you've done a fantastic job, we don't have any questions, we sign releases and we're good to go. If you have a situation where one of the beneficiaries is disabled, or they're a minor, so they're not 18 yet, or they've simply refused to sign that release or refused to approve the accounts, then you have to go to the next step, which is the formal procedure of getting a judge's order in lieu of that consent and approval.
Right. Okay. So what are some of so that's why you have to do one. And what are some of the specific contexts in which it might be necessary for you to go through that whole process?
So if you've got a incapable beneficiary, for example, they're simply not capable of signing a release or approving. And so you need somebody to step into the shoes of that beneficiary. If you've got a competent beneficiary who is perhaps questioning a lot of your decisions. If they are saying, why did you make this transaction? I don't think you took enough money for the house. Why did you pay this person to clean out mom's garage? You can sometimes proactively say, instead of answering all of these piecemeal, I am going to start the court proceedings. I'm going to seek a passing of accounts. And you can create the mechanisms through which those disputes can be resolved in total, rather than 6 months of going back and forth piecemeal on your Excel spreadsheet.
Right. Okay. So I see how the process could be almost, attractive to some. So what does a passing of accounts from a procedural standpoint look like?
So in Ontario, our passing of accounts are done in the Superior Court of Justice. It's the same courthouse that you would file your probate application in. It's the same courthouse that you file like civil litigation cases in. It is a specific type of court application, so it's got its own forms, it's got its own rules under the rules of civil procedure, which is why usually a lawyer gets retained to assist with it, because it is a very particular type of proceeding. And if you're not comfortable navigating the Ontario Court Forms website, it can quickly become quite daunting. Procedurally as well, if you are dealing with an estate that's got a minor beneficiary or it's got an incapable beneficiary, you have to put the appropriate government office on notice too. So you got to make sure that you're properly serving the office of the public guardian and trustee or the office of the children's lawyer. One of the things that I think a lot of our clients don't always know when they come to us, like they say, listen, I've Googled, I think I have to do this. What they don't often realize is that there's actually a statutory period of time in which you have to allow the beneficiaries to read and respond to the application. So if all of your beneficiaries are within Ontario, you have to give them 60 days. If you have one or more beneficiaries outside of Ontario, you have to actually give them 75 days before continuing with the process.
So this is just kind of a quick follow-up, what does the process look like? Say you send it out, that amount of days passes, and then no one responds. What kind of happens then?
So that would be what we would call an uncontested passing of accounts. And so what you as the trustee are allowed to do is you can then file a paper application record saying, I served everybody, here's my affidavit of service, here's a copy of my accounts. Nobody's requested a copy, nobody has filed a notice of objection, nobody's requested further notice. Here is the court order that I would like to have, please sign, and it will go to a judge's desk. They will make sure that everything that you needed to provide has been included. They will sign the order and they will send it back to you.
Okay, great. Okay, so speaking of that, obviously there's a lot of work involved. Sounds a lot like a lot of lawyers doing work. So what do the costs for the estate trustee or POA look like for doing a passing of accounts?
So there's a couple different components to costs in preparing this, because what some people don't realize is that if you are going to submit a passing of accounts, you actually have to put your accounts in the form required by the rules of civil procedure. It's a specific layout of information that the courts want to see it in, because if things become contested, it can easily be referenced by, the capital receipt number 1 or capital disbursement number 43. So we've done it's done strategically for the litigation side, but it is a style of accounting that most clients do not know and find confusing, and most accountants call me and say, why are you doing it this way? Because I have to.
Right. Right.
So you have to have those accounts prepared. And then there is the actual filing fee for passing of accounts. That is set by the government. This year it's $432 to file a notice of application to pass accounts. And then you have your legal fees for like preparing the court paperwork, the draft notice of application, the draft order, things like that. If things are all uncontested, the court actually has a tariff system on what is supposed to be charged for these passing of accounts. So if your estate is $500,000 approximately, the tariff says that your lawyer fees should be about $3,000.
Okay. And then does it kind of scale up as you get into the bigger estates?
It
Is that how that works?
does, yes, because the idea is that with larger estates, there's generally more time associated with preparing all of the accounts and the draft orders that have to go with it.
Right. And is there sometimes kind of an initial cost? Does the initial cost sometimes get covered by the estate itself as opposed to the person acting?
Yes. So usually as trustees, you are entitled to be reimbursed for expenses that are appropriately expenses of the trust, whether that's the estate, a trust, or the funds that you are managing as a power of attorney, because it's an administrative step. Now, that being said, there's always a few cases where if you've tried to obtain a passing of accounts and a judge has found that you have been unreasonable, or you've perhaps things have gotten contested and you haven't kept good records, the beneficiaries were entitled to request all of these things, and it's actually your fault that this has taken so long and has become so expensive. They may order that you reimburse to the trust fund whatever you had already paid out, and that you should personally be bearing those expenses. But sort of as a first step, usually it's all paid from the estate funds.
Okay. All right. Perfect. Okay. I'm not going to lie. It's kind of starting to sound a bit more like an emotional and financial hassle. So I think now would be a good time to go maybe broach into this topic. So what would you, as an estates administration lawyer, use to wow, I can't talk. Avoid this process altogether, and B, make it run as smoothly as possible if it were to come about?
I think the thing that people don't always appreciate when we start this process is the more work that you have done to keep good books, the easier it's going to be for everybody.
Right.
If you have kept all of your receipts and accounts in a notebook that you've written in paper, that's going to take more time to turn into a proper set of books that we can report to everybody else. But if you've kept a really nice Excel spreadsheet, if you've been reconciling it with the bank accounts, if you were within $5 of the dollar balance of the bank account already before you've even come to me, fantastic. We can report this to the beneficiaries very quickly. We can show them everything. And generally, if they've got a good explanation for what each of your line items are, they're going to accept your accounts. Where we see conflict is when people tell me they don't remember what this expense was for. They've paid for something in cash, so they don't have a receipt for it if somebody asks, hey, where did this $500 go? And if they have reimbursed themselves for things without providing information in advance to say, hey, I bought X, Y, and Z at Home Depot to help fix up the house while I was there getting my other stuff, just so you guys know I'm reimbursing myself for these things. And keeping the lines of communication open during the entire process can make providing the accounts a lot easier on everybody. Now, if you've got a minor beneficiary, so they're under the age of 18, the Office of the Children's Lawyer is only involved until they turn 18. So I've had a couple of states where we have a beneficiary who is 17 and a half, and I have sat down with the estate trustee and I have said, listen, it's going to take me 3 to 6 months to get you a court order, or in 6 months they turn 18 and they can sign the release to you after they've
Right.
had their own legal advice, and they've had somebody could have the opportunity to tell them whether or not they should be signing. But if you're very close to somebody being the age of majority, and that is the only reason that you were seeking to pass accounts, as much as I would love to be a greedy lawyer, sometimes it's not necessary.
Right. Yeah. That's a good thing to keep in mind. Okay. So I think we've spent a lot of time kind of on this estate trustee side of this, but
Mhm,
our practice also includes, dealing with the beneficiaries. So
mhm.
you spoke a bit earlier about beneficiaries challenging accounts. What are some of the red flags that you would look out for on that side of the equation to know, you should be questioning the conduct of an estate trustee or a power of attorney?
Yeah, okay. So if you're on the other side of this, if you're a beneficiary who has received accounts or who is being asked to sign a release and you haven't seen an accounting, things that you want to make sure you are looking out for is, have there been cash withdrawals? And if there have, do you know exactly where that cash went? If a huge amount of compensation is getting claimed, especially if it's disproportionately large when there were already lawyers and accountants and real estate agents and like other professionals involved who have taken on some of the burden of administration. The reimbursement for personal expenses, again, if as soon as we start hitting high three figures, four figures, a lot of people start to feel very uncomfortable over it. They've reimbursed themselves for this and I don't know what it was for. I don't know why they incurred this expense themselves. The other thing that comes up a lot of the time, particularly if somebody's preparing accounts without the assistance of a lawyer, is they start the accounting, January 1st, but the deceased died back in October. So what happened during those 2 months that you haven't told me about?
Right. Okay. Okay. I was actually going to ask you about that because I knew, do you ever get in trouble? Because obviously there's delays sometimes in between when your appointment gets like approved or issued and when, you're the executor, you're going to have to take care of, some of the bills that are coming in. So do you include that period of time where you're still applying for the COA in these accounts?
Yes.
Yeah.
So as soon as you have started managing assets, that's when you have to start accounting. So even if you were applying for a certificate of appointment and it takes a couple months to get issued by the courthouse, if you are accessing one of the bank accounts that was perhaps joint with you to pay certain assets, or if you are taking invoices to the bank and having them issue checks for payment, as soon as you've taken responsibility for those funds, you have to account for that period of time.
Right.
So unless you didn't touch any bank accounts until the certificate of appointment was issued, you need to account for your actions taken during that period.
Right. Okay. What are some other kind of examples of issues that are challenged? I know I did a Willpower Wednesday earlier with Adam, and
Mhm.
we talked about an estate trustee who had sold a painting. And I guess the beneficiaries weren't really a fan of how much the painting had been sold for. So is that something that you see come up quite often?
Yeah, it comes up quite a lot when like the family home is sold to the neighbor or it's sold to a family member, so like a non-arm's length party,
Okay.
because everybody in those situations thinks that they deserve a deal. Everybody always thinks that, well, we're not paying realtors, so therefore everybody should be getting paid a little less. And because it wasn't sold on, the open market, it's an opportunity for people to challenge whether or not that was true value for the asset. The other thing that quite often gets challenged is if there's missing income. So if there was a rental property or if somebody was occupying the property, the question is, should they have been paying rent and where did that go? The timing of the estate, if it's sat in a bank account for a year and there hasn't really been any activity, there hasn't been any need to sell anything, why did it take so long for it to get distributed, and should you take less compensation because you dragged your heels a little bit? The other thing that I find that people will often flag as beneficiaries is, are you paying for certain professionals for your benefit or for the estate's benefit?
Okay.
And so this often comes up when estate trustees have obtained legal advice and making sure that the invoices that are issued to the estate are properly for estate matters and not for any of their personal interest.
Right. Okay. Okay. Quick question on kind of the timely manner ones.
Mhm.
I know that kind of estate trustees are afforded, reasonable amounts of time because sometimes, it's hard to sell the house, like you mentioned.
Mhm.
When do you see, when have you ever seen kind of a timely manner complaint, or at what threshold does a timely manner complaint really become like a realistic kind of, qualm of the beneficiaries?
I'd say once we start hitting 2 years and there hasn't been a lot of movement, that's when we really start having issues. We've had some interesting cases come out in Ontario about the obligation to make an interim distribution, even if you have to do a holdback for income taxes. So, not to get too wildly off topic, but sometimes you have to file 1 or 2 income tax returns.
Right.
And if you're sitting on a big pile of cash and you don't need to hold all of it to wait for the tax bill to come in, the Ontario courts are saying you need to start distributing some of that. And so if you're sitting on that for 2 years, not giving anybody any money, you could really be looking at a claim that you are not administering in a timely fashion.
Okay, great. All right, so I think we've hit the 21-minute mark. So usually I run out of questions at that point, but if anybody in the audience would like to ask any questions that you have about the presentation, please feel free to pop them in the chat and I'll pass them along to Tristan. And we'll give everybody, a couple seconds here, 30 seconds here to get their typing fingers working.
Well, I'm very good at my job, so clearly there's not going to be any questions about this very simple area of the law. See, look at me. I'm so good at my job.
I know, it's impressive. I'm always impressed. All right, well, I think that'll wrap up our time for WillPower Wednesday, if there aren't any last minute questions popping in here. So thank you for joining us. Hopefully after that, you have a better understanding of passing of accounts and the context in which they become necessary and the unique challenges that they represent. We'll be back again next week. This time I'll be back taking over the host chair one more time, and I'll be joined by Cambridge LLP's Adam Capelli when we'll be discussing recent technological advancements in estate planning and the evolving role of lawyers. So keep an eye out for that notice. Bye for now.